Welcome back to the morning show here on Arise News for a discussion of the need for judicial reform to facilitate the trial of thousands of awaiting trial inmates in Nigerian prisons, as well as a look at the ongoing cases of Omoyele Sowore, the leader of the Revolution Now movement in Nigeria, and Sheikh Ibrahim El-Zakzaky, the leader of the Islamic movement of Nigeria, also known as the Shiites group. We are now being joined by Liborous Oshoma, head attorney, Liborous Oshoma Chambers. Liborous, good to see you again.
My pleasure.
You're welcome. Quickly, let's start with El-Zakzaky, which is the story in the news. We're told by the Islamic movement of Nigeria that the federal government has connived with the government of India to make sure that El-Zakzaky and his wife do not get the proper attention that they've been asking for, access to their own doctors, and also, they didn't want too much security around them, too many armed policemen, they allege. And, now the Indian government and the Nigerian government, we have been told, on the basis of concrete evidence provided by the National Intelligence Agency, NIA, have decided to send them back to Nigeria. I'm sure you've been following the back and forth and the controversy, the drama around this issue. What's your take? Do you think that this is an abuse of the court order given, allowing El-Zakzaky and his wife leave to travel for medical treatment?
Yeah, thank you. First and foremost, for the benefit of our viewers, I think there's need to place both sides of the story, on the table so that people will understand. The government had said that El-Zakzaky had breached the terms of his medical bail, that on getting to India, he became very rude and aggressive, and he was, though he was the one that recommended the hospital in India, his doctors recommended the hospitals in India, and he got there and that he became very unruly, and that they have intelligence reports provided by NIA that he wanted to ambush the federal government to seek for a restraining order, restraining the government from flying him back to Nigeria. And so on the basis of that, they decided to bring him back. But El-Zakzaky and his team had said the government is very economical with the truth, that on getting to India, that the doctors recommended the hospital in India, but on getting to India, that his doctors, his medical team, will refuse access to him, and that they were excessive, that he never requested to stay in a five-star hotel, and that there were excessive securities around him, and that there were connivance between the Indian government and Nigerian government to deny him, his personal physicians, access to monitor the medical treatment. And so to that extent that he was the one that requested to come back, and that the Indian government even gave him 2 hours ultimatum to decide whether to be treated. And he said he didn't need 2 hours, that 2 minutes was enough for him to decide. And even 24 hours thereafter, that there were still no decisions from there, but that he requested to come back. But that said, also, I would want us to, remove the character, the persona of El-Zakzaky from all of this, so that we understand, we get a clearer picture. If it was somebody else, like, let's say, Reuben Abati, for example, that had been granted leave to travel for medical treatment, would, public opinion on the matter have been different. And so to that extent, El-Zakzaky, even though undergoing trial, he's not been convicted, has a right to who should attend to him. Because the essence of government is for him to be fit to stand trial. That should be the sole purpose of government, for him to be fit to stand trial. And so if the man is not medically fit, that means he won't be able to stand trial. And that means the justice of the case will not be met. And so if you want the justice of the case to be met, he should have access to his personal physicians, who should at all points monitor whatever should happen to him. He can even refuse, any doctor from touching him. It's his right, because he's not been convicted. But the part of excessive security personnel, that also I would disagree with El-Zakzaky and his team, because we're talking about medical bail here. He's not a man who is on bail. He's still on undergoing trial, still in detention. But all of this, the problem we have with all of this, just before yesterday, the president assented to a bill to change the name of the prisons to correctional centers. It's not just about the name. If we had working and good medical facilities in Nigeria, and our prisons are up to date, you won't need to take prisoners or accused persons to India or any other country for medical treatment. We would have the requisite medical facilities to treat them here. But because our health facilities are so deteriorated to a state that even our president does not have faith in our health system, it becomes very easy for us to take, accused persons abroad. And so that's why we're having all of this, crisis back and forth. And so it depends on the side that anybody is leaning to, and that will determine, the conclusion they reach. But I think, in my opinion, because you asked me what my view is, I think, in my opinion, that the arrangement so far had been very tacky, and government could have done better than they have done.
Well, before I get to my question, I have to say, Dr. Abati, you will never be granted medical bail or any other bail in the mighty name of Jesus. Ever. We don't use...
Thank you very much, Pastor Tundu.
We don't use negative examples, Liborious. We rebuke it.
Yeah. Amen.
Yes. Now to the question. The court of public opinion is one thing. What is the legal process that's now going to follow since El-Zakzaky is now back in Nigeria? Does he have to reapply for medical bail?
Yes, he will. The court granted specific terms, so he will have to apply to vary the terms of the conditions granted by the court, because the medical bail order was specific, directed to a specific hospital in India. And where problem is going to come from, if you remember, after that bail had been granted, the Kaduna state government attempted varying those terms without a court order. And so this will open opportunity for them. If El-Zakzaky applies to vary those orders now, they might open opportunity for them to throw in that application, their initial application, to request that on the basis of what is in the public opinion, what's in the public domain, that El-Zakzaky's stringent conditions, should be included in the conditions that will be varied. And so that might bring us back to square one. And so that's why I felt that all of this, the government ought to have ensured that they cross their T's and dot their I's even before, flying him to India. And then I really don't see any big deal about allowing his medical personnel to monitor any treatment you're going to administer on him. Because we remember what happened to Yaradua in Nigeria here in prison. Also, you remember the late Gani Fahimi stories back and forth in prison. We also are very aware of the Obasanjo story in prison here. And so anybody that is undergoing trial in Nigeria would want to be very careful with the Nigerian government when it comes to treatment. And so I also expected that for a government that is preaching, a departure from old ways of doing things, we'll say change, I expected that, the approach would be entirely different and not the military style of doing things. And so, you say El-Zakzaky is a threat to national security. And because of the international politics involved, you want to be very careful. But also, there's need for you to ensure that, to a very large extent, you are transparent in your dealings with him. Allow his personnel, since you have allowed them to follow him, allow them to monitor whatever. Because if anything happens to him, if the medical team, if the medical team that are administering, treatment on him are the ones recommended by the government, without his team, if anything happens to him, what we saw in Abuja in the past few weeks would be a tea party compared to what, And so I had expected that the government should try as much as they can to ensure that, they are transparent in their dealing and not to try to swing public opinion, by narrating, according to the spokesperson of the group, by narrating, and then the video clips from El-Zakzaky himself, by narrating what actually did happen.
But speaking of those video clips, he actually then admitted himself that the reason he didn't want to accept the treatments was because he wasn't comfortable with the doctors. They wanted to start the process all over again of checking what was wrong, and he didn't believe he had to go through that. I don't think that's a strong enough reason not to have wanted to have received the treatments if really and truly you were in as much of a dire state as they made out to be. But healthcare is a fundamental human right. Now that he's back in Nigeria or coming back to Nigeria, what is the step that the government has to take? Does the government still have to grant him that right, seeing as they can play the card that we've already given it to you and you denied it? Or is the government just going to let him do whatever he wants? He's going to go back into detention and healthcare becomes his own business. What is the next step? It's
always been his business. Like I said earlier, your question is a hydra-headed one, so permit me to take the first part. When it comes to medical health, I gave you instances of Yaradua, Gani, and, so many others, and so many other Nigerians that have died, unannounced. And so if the man says that he's not comfortable with the doctors, and then if you read further, if you watch the clip further, he also said that he wants his medical doctors to monitor the process. And so if he insisted that he wants his personal physicians to monitor the process, what's the big deal about allowing them to monitor the process? If the personal physicians are there, there are some checks you conduct and they say, okay, no, this one we had done before. Or you want to do reconfirmation checks. It's normal to do reconfirmation checks. But when you now refuse his medical team, there is a problem. There you raise suspicion. If you suspect that the man is being mischievous, don't give him room to further act, the script. Put your cards on the table while you monitor him from wherever. We're talking about intelligence gathering here also. And then on the issue of what the government can do, his health had always been his business, not the government's business, even though it ought to be government business because government ought to ensure that everybody who is standing trial is fit enough to stand trial. But he has his followers and his medical team has consistently complained that his health is failing him, he has glaucoma, and that there's a bullet lodged in his body, and so he has leads in his body, and so all of that he needed treatment abroad. And on that note, the court had looked at the conditions and granted him medical bail. And so it is for him now to come back and apply that those bail terms be varied. It is for the court also to look at the pros and cons and decide whether they would vary those terms.
We have to take a short break, and then we'll come back and we'll continue with the conversation. Stay tuned. We'll be right back. Welcome back to the morning show here on the Arise News channel. Still with us in the studio is Liborous Oshoma, head attorney in Liborous Oshoma Chambers. Now, Liborous, we've been talking about El-Zakzaky. Let's look quickly at another issue. FCT indigents. Some of them have gone to court seeking an injunction to restrain President Muhammadu Buhari from inaugurating the cabinet as planned on August 21. And their claim is that a court had ruled, the Court of Appeal, Abuja Division, had ruled on March 21, 2019, that the FCT is to be treated as if it were a state, and on the basis of that, they are entitled to have their own slot in the light of the constitutional provision that says every state must have at least one minister. The court will rule on that injunction on Monday. Now, should the court rule against the federal government or grant that injunction, what are the implications?
Why not wanting to preempt the mind of the court on whatever it would say? The implications might just be, okay, nominate a candidate from FCT. Since you have ministers from all the states of the Federation, excluding FCT. And so to that extent, let somebody be nominated from the FCT. And so once that is done, then, because what they are...
But there are some Nigerians who are arguing that FCT does not really belong strictly to any indigenous group, that is federal capital territory belonging to all Nigerians. And that on the basis of that argument, FCT people, indigens, cannot insist that they must have an indigenous face.
That is a far-reaching position. And all of these are found by our knack for indigenship and settlership, you find out that, I did say on this program sometimes ago, that there are some persons now, in the near future, they will be without identity. You are in Lagos here, you live in Lagos, you have your children in Lagos, you grew up in Lagos, yet you are not an indigenous of Lagos.
Or they will be stateless.
Exactly,
like the Rohingya people.
Exactly. And so then, you are originally from, let's say, Kebbi, Edo, or Imo states. But your children grew up here. They hardly visited home. They can't contest the election here, not because the Constitution says so, but because of the style of politics we play, indigenship and settlership.
Lagos may not be a good example. Because we have a section of Lagos where they have members in the House of Reps.
Even now.
And they are going to have a commissioner very soon.
Even you have two commissioners, one from East and then another one from the Fulani extraction. So Lagos might not be a good example. Let's take Edo State, my state, for example. You live in Edo, you're an Igbo man, you live in Edo all your life. And then your children go home to Imo State, they want to contest for election. They say, no, you are not from, nobody knows you here. And in Edo, you can't run for elective office. And so it is because of that attitude that you see people from the FCT. The FCT is the Federal Capital Territory. It's supposed to be, a convergence of everybody, every Nigeria in no man's land. But because even in Lagos here, when Lagos was the federal capital, it still belonged to certain persons. And so that is why you have the Gwaris in FCT saying, look, this land originally belonged to certain persons. And so you can't deprive them of the entitlement that should accrue to states. And then also, even though the courts, I don't know why the federal government didn't challenge that decision, that, and also do not think that the Court of Appeals position was solely that the indigenes of the FCT should be treated the way you treat, indigenes of certain states, because the FCTs don't have governors. They have ministers that are nominated by the president. So it is not a federal structure like you have state governments with commissioners nominated by the governor, but in the FCT, it is solely administered by the federal government. And so to that extent, there is a departure. But here, the problem here is about equity, and good conscience. And so if we want to be equitable, even though the Constitution says, at least one minister shall come from each state, but the Constitution does not also say that the president, it is not explicit that the president must nominate, if you don't have 36 portfolios to fill, and that you must create 36 portfolios. And so to that extent, but because of the brand, like I always say, the brand of politics we play here, we'll always insist, this minister must come from here, or that other minister must come from there. That's why now you have some persons saying, look, since there's no minister from the FCT, and so somebody must be nominated from the FCT. And also, we should also remember that, yes, why this also encourages inclusiveness. But really, we need to begin to look beyond this from my side, from your side. Because Obasanjo's 8 years in office, I didn't see the good he did to the average Yoruba man. Jonathan's 8 years in office, apart from enriching a few persons in the South, I didn't see the good he did for the average Otoke man. He didn't change Otoke. I went to Daura recently. I even visited the emir of Daura. I did not see any drastic change in Daura, not talk of Castina, with Buhari's presidency. And so this attitude of it must come from my place, we should begin to depart from it. He who is competent should be appointed to fill some vacancies. Why there's need for us to consider, inclusiveness. Let's find a way of also including people, from other sections in government. But it should be based, firstly, squarely on merit before you begin to talk about indigenes and who is not indigenes.
Absolutely, but we do have these considerations. We're quite sentimental about certain things here.
Yes.
But I want to move the topic now to #revolution now. And I don't want to look at Omoyede Sowore initially. I want to look at the DSS. And Afe Babalola, SAN's recent comments that the DSS has no powers of arrest. It got me thinking, what is the DSS? It used to be SSS. Who woke up, changed the name, who woke up and changed the functions? The SSS was created, I mean, earlier we talked about the NIA. That was also created by an Establishment Act. It gives you the name of this body, tells you the limits of their duties, their mandate. The SSS, their job was protecting the president, vice president, governors, former heads of state, what have you. Not to go around arresting people. And intelligence, yes, but not to go around arresting people. So that's a great point that he made. So let's talk about the arrest, the legitimacy of that arrest, the fact that it was preemptive. There had been, he was arrested, Omoyele Sowore was arrested 2 days before the August 5th proposed revolution. And we were saying yesterday about what's in a name. A rose by any other name would smell as sweet. What is a revolution in this context? Can that be attributed to treason, treasonable felony, or acts of terrorism? Because that is the act that was cited by Justice Taiwo's Section 27, subsection 1, saying that he has the discretion as a judge, that may is directory and not discretionary, to remand Omoyele Sowore for further 42 days based on video evidence adduced by the DSS.
With all due respect to Justice Taiwo, my former NBA chairman, my friend then.
He's no longer your friend?
He's now
because he's on the bench?
Yes, he's now on the bench, and then so I mind what I say.
He's now my lord. Yes,
he's now my lord. And when it is, we all know that shall is compulsion. When it is may, it's discretionary. And so I think that now it is very easy and common for government to forum shop which court to go. And it started from the sting operation on judges and then to the recent nomination of the CGN, the present CGN, with all due respect. And so I think to some extent also the judiciary, has been cowed. And that's why I fought that ruling completely. And then also, starting from the act establishing the SSS, somebody just sat down and said, oh no, SSS is too stiff a name. Let's call it Department of State Security. If you look at the act, nothing has changed. The name had not been amended. It's still SSS. At a point, it was a battle between the media and the DSS on which name to address them as. Then, secondly, their responsibility is to gather intelligence and then pass such intelligence to the appropriate authorities like the police, who are constitutionally empowered to make arrests. But in this case, we have seen successive government use the SSS, the DSS, to arrest indiscriminately, in some cases, take you through psychological torture. In some civil cases, civil matters, you see the DSS will come in and arrest, and, under the purview of threat to national security. And then this government also had worsened matters when the Attorney General came on air to say that, including the president, that once there's a threat to national security, the rule of law can be suspended, citing a Supreme Court pronouncement. But forgetting that it was a court's pronouncement on national security vis-a-vis the rule of law and not an individual's whims and caprices. And so, when you now begin to leave the dictate of national security at the whims and caprices of individuals, it will be subject to abuse, because law regulates society. It is the law that should determine what is national security and what is not national security. And like you rightly said, what's in a name? I can decide to call myself Liborous Oshoma, the revolutionaries. And so does that make me, does that make it treason? If I decide to call a protest revolution, I expected, because you see, Omoyele Sowore, this government, when they were in opposition, they wined and dined with some of us, including Omoyele Sowore, who were beautiful brides at that time. It was easy for our opinion to matter to them. But now, when you criticize these same people, the way you criticize previous governments, it becomes either treason or a no-go area. You're called names. And so, but unfortunately, what the government is doing, they are if you go through history, everybody that they had taken through what they are taking on Omoyole Sowore through becomes, years later becomes an idol that people see as the voice of freedom. And I expected the government to have said, okay, yes, this man had called for a protest. Whatever name he calls it, let's watch out. Let's protect those that will not participate. And then let's watch the protest. Now you're looking for evidence to charge him. That means there was no offense initially committed before the arrest. Because if there were any offense committed, the moment he's arrested, you would have charged him. But since there's none, now you are looking for evidence. Well, you're asking court to give you extra days to begin to investigate.
At this point, we need to thank you very much.
My pleasure.
Thank you for always obliging us.
Always.